Welcome, folks, to the seminar on January 2018 amendments to LA FOIP for Boards of Education. I'm one of the solicitors with the SSBA Legal Services. With me today is one of the other solicitors with the SSBA Legal Services, and we're very pleased to also have with us the Director of Compliance with the Office of the Information and Privacy Commissioner. As Director of Compliance, she supervises those folks that we deal with when we have issues with privacy and access concerns, the analysts here at the office. 14 years with the Office of the Information and Privacy Commission. And it's interesting to also note that has been a high school teacher, so she's very much familiar with the education environment. And I know that some of you have also heard speak, and she's certainly very well versed in the area of education. So I'm going to start with turning this over to introduce the work that we're going to be doing today.
Hi, everybody. Unfortunately, the commissioner was not able to join us, but he sends his apologies. We will do our best to get through the content. We know it can be a little bit heavy when we're dealing with amendments to legislation, but we'll do our best to make it entertaining. We will also be taking questions, which then we will respond to throughout the presentation if we find that it lends itself to discussion at that point. If not, we will hold to the end of the session and answer the question then. So to give an overview of what we're hoping to cover today, we're going to start with the duties of the boards, including policies assisting notification of breaches, dealing with access requests, fees, corrections to a record, contracts with information managers, talk a little bit about integrated service information sharing agreements, which is a mouthful, the reviews by the commissioner, appeals, how we deal with consent, new offense provisions, and what you can do in order to get up to speed and to be prepared for making these provisions practice in your everyday work. A little bit of disclaimer, anytime this office is involved in a presentation or if we're providing any kind of consultation work, we have to be careful as an oversight body not to give what we call an advanced ruling. We are responsible through an investigation or a review to take a look at all the facts, take a look at the law, the specific circumstances, and only then come up with formal findings and recommendations that the commissioner issues in public reports. So what I'm providing today is non-binding general summary advice. And especially when it comes to new amendments, we haven't tested all of the changes to see exactly how they will change the practices that you're doing on a day-to-day basis until, of course, a complaint comes to our office. In addition, if we have reviews or investigations that are underway, I am unable to comment on those. If there has been a report issued, I definitely could comment. So in terms of the amendments to LA FOIP, and that's the Local Authority Freedom of Information and Protection of Privacy Act, or we call it LA FOIP. It was, in terms of the amendments, they came into effect January 1st of 2018, but there were also amendments to the regulations. So now we'll switch gears.
Hi, I'm going to talk a bit here. This is grouped together as the duties of the board. And what's happened with the changes to the legislation, there are some very specific duties that are now set out for boards that were not in existence before. The first one I'd like to talk about is the duty to protect, which is an interesting name for what's actually contained within that duty. There's a new section of the Act, and we had sent out to all of you a copy of a link to where the legislation is and to where the regulations are. So we haven't listed on our slides the exact quotes from the legislation. We've summarized it, but if you want to see the exact wording of the legislation, please feel free to look at the legislation itself for that particular wording. So the new section 23.1 sets out a requirement for the board to establish policies and procedures. Now, what those are will depend entirely on how your board conceives it, whether it be at a policy level or whether it be at an admin procedure level. We're talking here about something that your board does that sets out what employees are supposed to do when they're dealing with these particular issues that are required to be addressed. So one of the first things that you have to, and it's a very general requirement, is protecting the integrity, accuracy, and confidentiality of the personal information in its possession or under its control. As you can see, that's a very, very broad statement. And so we're talking here, covering everything, starting with the collection, right, of the collection of the information, what you should collect, how you should make sure that it's accurate, and all that sort of matters. How you use that internally, how you have the security, and we'll talk about that a bit more in a minute, how it's accessed by the individuals, how they access their own information, and also what and when and where you would disclose to third parties. How is that done? Who takes care of doing that? Who's got the responsibility for doing that? It's going to be an interesting balance between detail, between what the Act says and what should be covered in the policy. And before somebody asks the question about whether we have a sample policy, at the sasschoolsprivacy.com website, there are some sample policies, among which is a sample policy for dealing with privacy and access. That's a good start for you to take a look at as to what might be helpful for you. And there's also a document that has a checklist for things that should be included in policy and procedure. So there is some materials there, but I can tell you, because we've had a conversation with Diane, that we are going to be reviewing those, updating them in light of this new provision and this new duty that's been set out in the new legislation. And we will be updating those in the next couple months and getting some input from the Privacy Commission as well. So the next piece that's set out in 23.1 that has to be dealt with in the policy is protection against reasonably anticipated threats or hazards to the security or integrity of PI. We've used the abbreviation PI, as you may have noticed, for personal information. That's generally what school divisions deal with. So dealing with hazards to the security of it, loss of the personal information, and unauthorized access, use, or disclosure, or changes to the personal information. So, for example, in security, you're not just looking at you're looking at the physical protection, you're looking at electronic possession protection. You're also looking at procedural protections and things like making sure you audit things, making sure somebody's responsible, somebody's checking to make sure the policies are being carried out. So it's pretty wide ranging. And you'll note that the legislation is a requirement. It's not a may, it's a shall. It's you have to have the policy in place. If your board doesn't have it, you better get working on it fairly quickly. Finally, this section says that the board has to also establish policies and procedures that ensure compliance with LA FOIP by employees. Now, as an employer, that's a pretty broad-ranging responsibility and probably would be encompassed in large part by having in place good rules and procedures, and then very importantly, making sure your employees are aware of those policies and procedures, and again, checking to make sure that they comply with those policies and procedures. So now we'll talk with you about another new duty, and that's the duty to assist.
There was a question about where do you find these precedent policies, and you had suggested that they could look at www.saskchoolsprivacy.com. That website is listed at the back of the presentation in case you miss it. So it's available there if you need to look at them, but they need to be updated.
And the place to look on there is under the tab that says Central Office. And if you look under that tab and to your left, there'll be a listing of things and it'll say sample policies. And if you look under there, that's where you'll find the existent sample policies. So they're a good place for you to start. There's nothing wrong with them. They just may not be as detailed enough to catch some of the new provisions here. And I know that many boards, if not all of you, have some policy in place already. So it's a matter of updating and looking at that, and we'll certainly be helping you with that. Okay.
Now, turning next to the issue of the duty to assist, this is a new provision in our Act, and it deals with how school divisions need to assist applicants. So that's a very broad statement. The language is broad as well, similar to the other duty just described. So in the duty to assist, the head shall, so it's mandatory, respond to a written request for access openly, accurately, and completely. And those are very broad terms. So it may be helpful for you to know that there is on the Office of the Privacy website, Commissioner's website, a document entitled Understanding the Duty to Assist. So it's a brand new document that was created in January 2018, and it's a resource that's referred to at the back of the presentation, which you'll have access to later today, or this soon in any event. And this document describes their perception of the duty to assist. When we look at the concept of responding to an access request openly, they are recommending that that openly be interpreted as transparently, that the privacy officer should provide an explanation of processes, actions, decisions that they have concluded to fulfill an access request. When we look at the concept of responding to a written request accurately, the Office of the Privacy Commissioner has recommended that we consider that divisions ensure that it have received sufficient information upon which it has based its access decision. In this respect, we have to look at whether we've done an adequate search for records, whether we've done a thorough review of those records. And they've also recommended as a best practice that an index of records and what were located during the search, as well as when we give the index, they recommend giving the index of records, as well as whatever records we are providing to the applicant in full or part, and that be identified on the index of records. And that is what has been recommended as a best practice. When we contemplate the issue of responding to a written request completely, that again is a very broad statement, and they are recommending that the best practice may be including a brief explanation as to how conclusions were reached. So we need to contemplate this duty to assist in a very broad way so that we are responding in a transparent, as accurately as possible, as well as completely as possible. Some examples of this is that the board shall, on the request of the applicant, provide an explanation of any term, code, or abbreviation used in the information. So an example of that would be when we talk about VITRA, an applicant won't know what VITRA is. So it'd be necessary for us to describe VITRA in its full name first, then put the abbreviation so that people understand what that is.
I'm sure this clause was put in specifically for education because of all the acronyms we use.
And another example that they have provided is that, that the board shall, on the request of the applicant, refer the applicant to a body that is able to provide an explanation of any particular term that we are using.
Thank you. Just so everybody knows too, in terms of participants today, we will be following up with you directly and making sure you have a copy of the slide deck. And hopefully all the links will be intact and will get you to the resources that we're referring you to. So I get to talk about breach of privacy. What is a breach of privacy? Now, this particular section of the Act, 28.1, talks about certain types of breaches, and those are in the event that there has been some sort of unauthorized use or disclosure of personal information. I think it's important that we're all on the same page in terms of what these terms mean. First off, a use is sharing the personal information within the school division, the board itself. The second you're sharing that information with somebody outside of the school division or board, it's considered a disclosure. You lose control of that information because it's now in the hands of somebody else. And unauthorized simply means there wasn't authority under either LA FOIP, the regulations, or another law, or you didn't have consent to use the information or to disclose the information for those particular reasons. And it's not just the personal information of students. In terms of all of the information that a school board, school division, and everyone that works there come into contact with, there could be information about students, there can be information about parents, family members, others, and employees. So in terms of LA FOIP and its application, it applies to all personal information that's either in the possession or control of the school board. And possession is simply your physical possession, but you have to have a measure of control. So for instance, things that were provided to you that was unsolicited and has nothing to do with your mandated services, that maybe you don't need to keep it, you should just shred it. But if you actually need it, you know, you should be collecting it and making sure that it's safeguarded and only used and disclosed as necessary. In terms of control, that means that, well, maybe you don't have it in your physical record holdings. You don't have it in a computer. You don't have it in a paper physical file, but maybe a contractor has it and you have a right to manage. So you could demand that information come back to you. So in this particular case, there is breach notification that's required to the affected individual. We don't refer to them as victims, but rather an affected individual that will be affected by the unauthorized use or disclosure, the information being shared with someone that it shouldn't have been. But it's only in those cases where the board believes that it would result in a real risk of significant harm, which I will come back to shortly because this is brand new language for Saskatchewan. Even though other jurisdictions like Alberta and BC, they've been dealing with this for a number of years now under similar legislation. So in terms of when an unauthorized use or disclosure can occur, sometimes it's when an employee has access to that information, but it's not needed for their job. Or it can be accessed, and usually we use access in this term by someone viewing the information, they're reading it, or they're using it, but it's a third party. So it's somebody outside of the school division that's getting access to it. Or an inadvertent disclosure that's accidental. It could also be intentional, and that we often refer to as snooping. So it doesn't have to be one or the other. The result is still the case that there's a privacy breach. So in terms of avoiding these, two important principles to keep in mind is both the need to know principle, which is you get access to only what information you need for the purposes in which you are hired, which is to teach students, anything related to that that's consistent use or disclosure. And then the data minimization principle, which is requiring the least amount of personal information necessary for the purposes. So if there's only 4 data elements like name, address, gender, and grade that's required, then you don't provide a 5th. So in terms of real risk of significant harm, what does that really mean? And our office has put out a blog called Real Risk of Significant Harm that we hopefully have the link for you. And it talks about some risk of damage, detriment, or injury to the individual that is significant in nature. And we have some examples up on the slide, but in addition to those, it could be bodily harm, humiliation, damage to reputation or relationship, loss of employment, business or professional opportunities, financial loss, negative effects on credit reporting. The list goes on. And I know what's the most challenging is how do you know if the result of the information being leaked or shared with someone it shouldn't have been may result in one of these harms coming to the individual. And the reality is that it may not happen today, it may not happen tomorrow, but maybe it happens 3 weeks from now or even 3 years from now. And so it's making sure that notification is provided to the individual so that they can take some action to protect themselves.
The legislation uses the word reasonable. Could you expand a little bit maybe on how that fits with this reasonable in the circumstances to believe?
Right, and I think that's part of the assessment is that every school board, whoever is sitting down that's tasked with making this kind of a decision is you have to look at the totality of the circumstances, the specific data elements that are involved, and make that judgment call. I know one of the really sensitive pieces of information that sometimes is floating out there that shouldn't be is the health services number. Mm-hmm. Well, that in itself could be used, to steal someone's identity, medical fraud, et cetera, et cetera. So, when you start looking at some of those individual elements, that needs to be factored in making that call.
Okay.
So then what happens if you need to provide that breach notification to the affected individual? Well, we've spelled out some of the specific elements that should be included in the notification, and whether or not this is done over the phone, in a meeting, a one-on-one meeting, or a written letter to the affected individual, that is also going to be a judgment call depending upon the circumstances. I know in some cases, especially if any kind of a local authority wants to, maintain a relationship with an individual, sometimes that personal touch, I think, is the best option. But we've also had cases where there's been such a large breach that it's affected thousands of people, and the only way to reach them in a timely manner is to actually put a notice in the paper or on the website. And so you sometimes have to get a little bit creative in terms of how you provide that information to others. One of the elements you'll see too is to provide contact information for our office, because individuals do have a right to complain to us if they hear that there's been this breach. What we generally will do though is refer them back to you, because we know you're already addressing the incident, and we'll say wait until they're done. If you're not satisfied with their investigation, the steps they're taking to help prevent this from happening again, to contain the breach, then maybe we'll look at it at that point.
So the school division doesn't have to notify your office, but should it?
Well, and that's a really good question. What's interesting is that even though there hasn't been mandatory breach notification requirements in Saskatchewan forever, this of course is mandatory breach notification to the affected individual when there's a real risk of significant harm that's been determined. People and organizations have been proactively reporting to us for years. And one of the benefits of that is that we will help work with the organization in advance and try to work out all of the different areas of concern, provide some advice on notification, how to contain, where maybe the gaps exist and how you plug those gaps. And most likely our office won't then feel the need to issue a public report, because the organization has been cooperative with us and they've addressed everything in a timely fashion. So we're less likely to go to that extent, and rather we will resolve the file informally and close it.
In our experience, that has been the case. I know of several school divisions that have taken advantage of the advice that your office has given on those, and I'd certainly encourage any boards that are dealing with this. Certainly we can provide advice, but we would also suggest calling the office here for help in that.
What do you recommend as being the best process if a school division wishes to voluntarily report a breach? Should they communicate with your office by phone first, or how should they do the process, and what will happen if they start this process?
I think it's always best to make a phone call to our office and to talk it through. The odd time, we'll have an organization, an individual call us, and it won't be a privacy breach, because sometimes there isn't personal information involved. Because that's the interesting thing about the Act is we know what is personal information, but there's also particular sections that deal with what's not personal information, and we can help you navigate that and figure it out. Okay, let's shift gears.
So now we're going to have a section here that we're going to talk a little bit about dealing the new provisions that talk about the areas of dealing with access requests or disclosure requests, basically anybody wanting to have information. So this is a general heading for this topic. First, I want to talk a new section, 53.1. And this is one that almost goes without saying, but it's good that it's been said. Boards have to take reasonable steps to make available on its website all manuals, policies, guidelines, procedures used in decision-making processes that might affect the public, or provide those documents when requested in electronic or paper form. So this is all about some proactive disclosure, so to speak, of letting people know as a public entity what it is that you use to guide your decision making for, in our case, students and sometimes parents, and also employees. So it covers a wide range of documentation. One of the things that I can suggest is when it says make it available on the website, looking at your website, and if I don't know where to find this stuff by looking at your website, I'm much more likely to make an information request to you. But if it's easy for me to find this stuff, you're going to have fewer information requests. So think about the ease of access on your website itself in terms of the general public finding the policies and provisions that might apply to them. And it's also important to note that this section doesn't just say policies and procedures. We note the word manual and guidelines. And I know with a lot of school divisions, there's a level of policy procedures, and you might have a guideline or a manual. Those practical things also, they would be accessible if people made the request. So why not just make them accessible and easy to get at? That's a practical thing. Well, now you must make them accessible. In most cases, putting them on their website is enough, but for people that maybe wish to have them in paper form, you still have to do that and provide them in paper form now to the public. Coincident with this is the other, and it makes sense, is you can establish also categories of records that should be made available to the public with a reasonable time without them needing to make application for access. So this would be stuff that you would normally release without a question, but it cannot, and it cannot include personal information. Trying to think of examples of what might fit within here, within the education context. I think, for example, school personnel at a particular school and their contact information. It could also be things like schedules of events that are happening at the school. So school newsletters. The school division can set out categories so that if somebody makes application or wants these things, they just have to request it. They don't have to go through the formal application process. So you can identify these kind of records within the school division.
Just wondering, have you thought at all about how this will intermingle with the record retention guidelines at all?
Well, I think in terms of record retention, I think we would still follow the same rules there, this shouldn't really change anything. This is just making it easier to access things that already would be accessible by people. These are things that we would have to, in any event, if an information request was made, you'd have to give them. This is making, again, for the public, making it easier for them to get this without having to go through that formal process. So it shouldn't affect other matters. You should be making those decisions on an independent basis. In terms of making copies of these kind of records, if they're on the website and somebody wants an actual copy, can the board still charge for those copies?
Well, the interesting thing under LA FOIP is if fees can be charged, it's spelled out in terms of what those fees are and what can be charged. And so in terms of fees, they always talk about an access request that's made.
Yeah.
So the act is silent on that. Just like right now, and I know this happens across the board, whether it be government, even health trustees, there are certain records that they charge for, right? And that's under just disclosure. Yeah. Like if we're releasing records to you, we want you to pay some sort of a nominal fee. And so most likely we wouldn't comment on that, okay. But we haven't tested it yet.
Yeah, and I would think that for many of these records, it's probably easiest to just suggest they go to the website and deal with it on an individual basis. If it's something, my advice to a board would be, if it's something of a reasonable request that's not a lot of money, there would not be a charge. If it's an unreasonable request with lots and lots of documentation that will cost and take time, then we should consider that.
And I think that we will talk about fees a little later, but I think there should be a distinction between personal information versus information sought by corporations or corporate entities.
So there may be some arguments on that. So then we'll move to disregarding requests, which is...
You bet. What I think is really interesting is when we start talking about the access request process, we don't get a lot of requests for reviews in our office that do involve school divisions. So I'm not sure in terms of how familiar the group is, all the participants are with the process. So just really quickly, if an access request comes in the door, it's in writing or it's on the prescribed form that you find in the regulations, a clock starts. You have 30 calendar days in which to respond and provide access, or we're going to deal with a number of different issues that might come up in the course of that process that might have to be addressed further, either through a review process or informally. So disregarding a request takes place within that first 30 days. And what these provisions allow for now is that the school board can make an application to our office, to the commissioner, to disregard either an access to information request or a correction request. And I am going to split these up and talk a little bit more about correction later on. But within that 30 days, you make the application to us, and then we have to make a decision as to whether or not we agree that that request can be disregarded. And if it's disregarded, then it is as if it was never made. And so this is extinguishing an individual's right of access. So we've already anticipated that it will be a rare occurrence where the commissioner will find that there were grounds to disregard the request. In terms of grounds listed on the slide, there is a number of them. And in two of the cases, first, you have to have repetitive or systemic access to information requests or correction requests. And so right away, you can tell maybe there's some nuisance factor here. Because really, if you want access to certain records, you only have to ask for them once. You shouldn't have to ask for them 15 times or 45 times. Just once should be sufficient. But in addition to that, you'd have to demonstrate that it would also unreasonably interfere with the operations of the board. So what is it about these access requests that really would cause extra work to be done, more so than usual? And an additional reason would be that it amounts to abuse of the right of access or the right of correction. So again, it's maybe the mischief is there. So there's not a good reason for the individual to be asking for this in the first place. And then, of course, there's also frivolous, vexatious, not made in good faith, or involves a trivial matter. And, you know, we don't really have a lot of time to get into those, but do know in our guide to exemptions on our website, there are specific sections that detail what those mean and what kind of questions you can ask and answer in order to demonstrate that those do apply in the circumstances to convince the commissioner that they really should be disregarded. In addition to that, you know, that 30-day clock is important to us, and we want to expedite these types of requests because the clock gets suspended when we receive that application and we have everything we need in order to make a determination. So we will try to respond within, I think it's a 20-day period to make a decision on this. But if the commissioner decides not to disregard the request, then the 30-day clock resumes. Now, if you waited to day 26 to make the application to our office and we don't approve it, that leaves you 4 days to make a decision on maybe an access request that involves 1,000 pages. So we encourage you, if you're going to make that application, the earlier you can do it in the process, the better, maybe even around the 10-day mark.
I noticed that your slide makes reference to draft rules of procedure.
Yes.
Did you want to talk about what those are just briefly?
You bet. On our website, the commissioner has draft rules of procedure that we are taking comments on at this time. What it does is it lays out what is a review, what is an investigation, and what is required of you and the other parties. And we're trying to use as plain of language as we can. It's modeled after rules of court. And I know we'll keep it up there probably for another month at least to hear back from different stakeholders, and we'll make whatever necessary revisions that are necessary just to make sure again that it's in plain language and everybody understands what the rules are. Just getting back to disregarding a request, Section 7 is really important under the Act because it spells out what the school board has to say in a response back to an applicant. And because of course this is a new process, this new clause specifically says that if you're going to disregard or request that this application be disregarded, that you actually tell the applicant and you tell them the reasons why. And of course, there's a similar provision when it comes to correction.
Just want to make it clear here too, that this is an exceptional thing. We've had some situations in the past where people do become sort of silly with their requests. And this is a good provision to use, but just because something is difficult to do, just because it might involve 1,000 pages of a record, doesn't mean that this could be disregarded. It would be very special circumstances where this, the only one I can think of is one we had where a parent was asking continuously for making requests almost daily for information about a child, and there was nothing like this, so the board just made an agreement with the parent that they'd send everything about the child every month to the parent. But I would think something like that might be a frivolous and vexatious, something very out of the ordinary. I think you mentioned that, but I just want to emphasize that this will not happen very often.
And so far, we thought as of January 1, there would be this big dumping of these types of requests on our office, and we have not yet received one. I should knock on wood.
Yeah. So we'll move on to the refusal to confirm or deny. Previously, under the legislation, the Section 7.4 just said that a board could refuse to confirm or deny that a record exists or ever did exist if it was exempt from disclosure. But now that's been limited. So the only time that you can refuse to say whether the record is in existence is for access, are exempt from disclosure, it should be, are pursuant to those specific sections 14, 20, 21, or 28. So 14 is relating to law enforcement investigations. 20 is relating to danger to health and safety. 21 is about solicitor-client privilege, and 28 is about personal information. So if, for example, a request came in that they want a copy of a draft resolution or a copy of something that you think you don't have to disclose because it's advice from an official, or if it's third-party information, Previously, you could just say, we're not going to tell you whether the thing exists or not. Now you have to say, we have a record, but we are not disclosing it because pursuant to section 18(1)(b), we don't believe it has to be disclosed. So it's a little tweak on what we had before. It goes back to that whole concept that under LA FOIP, if you're going to refuse to give information, you must refer to the specific sections of the Act that allow you to do that. So this is another example of that. Another new section is 7.1. And this is one that is very helpful, I think, to boards. It says that an applicant who is asked to either supply additional details so that you can clarify what the request is, or if you've given them a quote as to what the cost would be and asked for the deposit, they have to respond within 30 days. If they do not respond within 30 days, then their application is deemed to be abandoned, which means you no longer have to worry about it. Now they can come back with a new application, but that particular one is abandoned. And that's, I know, already been used by at least one school division in circumstances where a quote was given and the person hadn't decided whether they want to go ahead with it or not. So at least it puts an end to a particular application. Now, again, there's a notice provision. So if the board is going to deem this to be abandoned, they have to give the notice to the person, says it's deemed abandoned, and you have to let the applicant know that they can ask for a review from the privacy commissioner. They have to ask for that within a year. So again, this is a great provision to at least put an end to some things, so you know at least it's either going ahead or it's been abandoned. A little bit about electronic records. Section 10 has been replaced. Previously, it just said that you could have to allow people an opportunity to examine an electronic record if it wasn't reasonable to reproduce it. It's now a little bit more specific. So you have to give access in electronic form if these conditions exist. So if you can produce it using normal computer hardware, software, and expertise that you have within the board, so you don't have to go out and hire expensive consultants to do it, but if you can do it within reasonable expertise, and if producing it wouldn't interfere unreasonably with the operations of the board, so this is not going to take up immense amount of time or person hours, and it's reasonably practical to do so. Whenever we see that word reasonable, we're talking about, let's look at this in regard to all the circumstances and determine whether or not this is the appropriate way to actually give access in electronic form. And it's important to remember in this conjunction that 10.3 remains the same. So when you're talking about film and sound video recordings, then you can allow the applicant to examine a transcript, give them a copy of the transcript, or permit them to just view or hear or provide them a copy. Now, in all of this, it's important to also remember none of this changes the fundamental concept that you still have to redact and redact appropriately. So whether you're doing it for an electronic record or some film or sound, you still have to ensure that you redact the information that cannot be released. So when you're doing the electronic form of it, that may be done in a different kind of way. So that's part of the electronic expertise that needs to exist in order to be able to do that.
Before we move on, there was a question which says, what are examples of records that we might define as not requiring an application? So I presume an LA FOIP application. Yeah. And that is set out at the outset of the Act.
And I think some of the examples there, like I think that relates back to the question of that listing of things. Like I say, for example, if a board were to say, anybody wants a copy of the newsletter, it's just there. So I think there's certain kinds of information that are non-personal information and confidential, not information of third parties. Any of the board's owned information would likely be on that listing. And one could even conceive of doing a broad general statement, like any board information that's regularly released to the public will be on this list. So you could make some general categories as opposed to specific listings.
And Section 3 of the Act, it speaks to information in which the Act doesn't even apply. And so, you know, it's information that's in a public registry, for instance, or information that's a matter of public record. Maybe it's available on websites. it's just information that generally is already available. It's out there, and there's different ways in which you can get access to it. But at any point, any public body, whether it be a school board or the Saskatchewan Health Authority now, because they're also bound by LA FOIP, you can come up with different types of records that you want to routinely disclose and that you know it's safe to release that kind of information on a regular basis. Like, for instance, the provision we just talked about in terms of the categories of records that can be released outside of the Act, or just because you know there's interest there. Mm-hmm. And often, we think of statistical information, aggregate things, details. There isn't any personal information involved, but for instance, maybe the media is always interested in it. And it could be something along the lines of, if there was violence in the school, were there in how many incidents within a year? Mm-hmm. That information in itself isn't about an identifiable individual, unless, of course, maybe you could tie it back to the one incident in that school that was in the public, was in the media already. So then you'd have to be a little bit careful.
I think the idea of the data that can't be identified individually is a really good category, where schools are producing their own internal reports and things, and there may be pieces of that they would regularly report.
Another question, in school videos, can they be viewed by parents? For example, security footage.
The quick answer to that is generally no. If you can do the kind of redacting that would allow them to view only their personal information of their child, and if under Section 49, it wouldn't be an invasion of the privacy of the student for the parent to view it, yes. Also, one has to take into account the employee that may be involved and whether or not there's ongoing investigation, so there may be those reasons to not do it. Generally speaking, it's a difficult thing to be able to do that, so we would generally advise against it unless there's some very specific circumstances where you can do that sort of kind of redaction.
Yeah. And I think what's interesting is when you look at the technology and how it's advancing, we have amazing blurring technologies that you can actually go in on a person's face and blur it out. But if that's not the system you have set up in your school division, it is going to be probably impossible for you to do that. So you have to work with whatever system you have, unless of course you find some hidden pot of gold and you can upgrade to a new system.
Well, and even in those circumstances, sometimes because of other information, you may, even though you blur the face, everybody knows who it is because, they have the tattoo, they have the jacket. So you end up, how far do you blur? What do you blur? Perhaps they have a distinctive voice or an accent. Do you blur then the sound, if there's sound on it? I mean, there's a number of technical issues. So we would generally suggest getting legal advice on that one before doing so.
Definitely. And a perfect example is we just dealt with a recent report that involved a dog attack. And the person who was attacked, of course, made a request to the city for information. There was photographs included about the individual who owned the pet. But of course, that's the personal information of the pet owner. And so in terms of the photos, the city went to great lengths to try to sever out or mask pieces of the photo that would identify or reasonably be used to identify the individual. And there was even a photo where it was the lower half of the person, but because of other unique identifiers, even that couldn't be released to the applicant.
And this goes not just for parents, but for police and others. I mean, there are provisions to allow police to view footage, but you should then rely on that particular provision and be clear that that's what you're doing, that it's in the course of an investigation at the request from the police to allow them to do that. So it's not just a general blanket that they get to come in and look at stuff either. So be very, very careful. I mean, we're a little bit off track on that, but that's a common question that I get asked.
Just to comment on that further, that if you're permitting third parties to do it, not only should you be clear to them, but also take a note and maintain that record as to what day, who you permitted access to, what portion of the record you permitted access to, and the basis upon which you're permitting access pursuant to LA FOIP, just so that you are very clear as to the basis upon which you've conducted yourself in this way.
I completely agree. And I think what's really important is that that's your proof. That shows that, because most disclosures are discretionary under the Act, and you have to be able to show if there was a complaint that came forward at that time, you had turned your mind to it, and that you were comfortable that not only you had authority to disclose the information, you respected the data minimization principle, and you have that record that is there, forevermore to rely on.
Excellent, yeah. So now we get to talk about the fees.
So we've already had an exciting interlude on the discussion of fees before, but I just wanted to let you know that there's been some minor changes to fees in the regulations. So if you take a look at section 5, subsection 2, you'll see that they have been simplified. So we have a less complex fee structure, which I won't go through because it's reasonably visible on the slide. On the next one, you see that there's discussion about electronic data, which is alluding to the issues I was just speaking about, and about how where there is a search and retrieval of electronic data, a fee equal to the actual cost of the search and retrieval, including machinery and operator costs, is payable at the time when access is given. The next slide deals with fee estimates, and it's now set at $100, so it increased from $50 to $100 by virtue of this change to the regulations in section 6, subsection 10. And the next slide deals with waiver of fees, and it's substantially the same as the previous regulations. The primary differences are twofold. First of all, there's a definition of substantial financial hardship, which is now found within section 8, subsection 2 of LA FOIP. And this will give us an opportunity to better understand what substantial financial hardship is, so that we can point to that provision so people can understand what exactly it is. In that respect, you can find it in the regulations, perhaps. I don't have a copy of them. Oh, I do have them here. And so you need to, when you have a request for waiver of fees, you should really pay attention to the basis upon which you are waiving those fees, and particularly the issue of substantial financial hardship.
And just an additional point on that too, in terms of a new clause, which is the first bullet. If the application involves the personal information of the applicant, then that's a circumstance in which you could and should be waiving fees for the individual, even short of that substantial financial hardship. Previously, there was a combination where it had to be in the public interest, and the individual would have to demonstrate that there was substantial financial hardship, which would be pretty difficult to demonstrate if you're, for instance, CBC. So I like at least that there's a separation now in terms of if it's your personal information, rather than, I'm just searching for whatever because I'm writing an article on a particular topic. But
there's no requirement that the board has to waive it. It's just a recommendation that they may waive it in those circumstances.
Yes, still a may, you bet.
And our advice to boards has certainly been, if it's about looking at an employee record or looking at a CUME file of a student, in those circumstances, the waiver of fees is perfectly reasonable. If, however, you've got something that wants a significant amount of work involved, then that may be a time of reconsideration. Yeah, so I'll just leave it there.
Especially if there's redacting involved.
Yeah,
exactly.
Yeah.
So the next section is correction to a record. Just a little more background on correction rights of individuals. So if an applicant makes an access request, they have a copy of their record, now they might go through it and decide, oh, well, I'm seeing some errors or omissions. And so the Act has already given the individual the right to raise that particular concern with you, to hopefully give you enough information to demonstrate how the information is incorrect or what's missing. And then you have the opportunity to respond. And a couple of things happens is you can either make the correction because you're satisfied that yes, the address was incorrect and I can prove that the address was incorrect, or no, that was the wrong year for my birthday, was actually 1989. Or if you don't agree to make the correction or the amendment, then what you do is you add a notation. Those two obligations already were there in the Act. What's new is what I was talking about previously, is making that request to the commissioner to disregard the request from the individual. And we have seen cases where applicants have come to our office requesting a review because they're upset that whatever the public body was, they were not making these correction requests. But often in those cases, they want every second line corrected and they have nothing to substantiate why, in their view, it's inaccurate. So in terms of that same obligation to provide reasons as to why you're disregarding an access request, this section of the Act deals specifically with what those reasons are in which you want to have this particular request for correction disregarded. So the next section is contracts with information managers. And this is something that has already existed in our Health Information Protection Act. So now it's bringing that language into LA FOIP and also our Freedom of Information and Protection of Privacy Act that applies to government institutions. So the terminology used in this area is an information management service provider. Again, these acronyms, but it's much less of a mouthful. So an IMSP is simply somebody that is providing some sort of a service that's involving personal information. And the first bullet, the second bullet, and the last bullet are more so services that you're entering into this agreement because they're providing the services on your behalf. So you're providing the information to a third party, and they're going to process, store, archive, destroy. They're going to offer information management services or IT services for you, or maybe there's a consulting service. But what you never do is lose control of that information because you're telling them, yes, this is what you're doing with the information, but I'm dictating, you know, what happens to that information. And if I terminate the agreement, you give that back or it's destroyed. The third is more about a data sharing agreement, because what you're doing is you're actually disclosing it to another party. So you have to be sure you have that authority to disclose, and they have to be sure that they have the authority to collect that information. And having this spelled out in agreement, which is my next slide, helps to make sure that everybody's following the rules. And the fourth bullet is combining records containing personal information. I think this is more so contemplating the future, which everybody seems to be going, which is data analytics. And I don't want to spend a lot of time on this, but there is data matching legislation that is moving through the House presently. And at some point, you know, it will provide further guidance, further rules in terms of what information can be shared for what purposes.
Are you referring to the House as being the legislature?
Yes, sorry. So the other part of this new provision is that it requires that the board enter into written agreements with all of their IMSPs. So if you don't have a written agreement, you now have to enter into one. It's a shall, and I think that's important. Wherever you see shall in the legislation, that means must. You have to have it in place, versus may is discretionary. So there's still a choice to be made. So some of the elements that have to be included in those written agreements are listed here. And, you know, it meets the requirements of this act and the regulations. That makes you look at the act and the regulations as a whole. So it's not just picking a section here or there, it's looking at the whole and how does it apply to that specific relationship that you have with that other party. And then the other amendment that was made to the regulation just goes a step further and introduces additional elements to include in those agreements. But I particularly like the last bullet, provisions for the destruction of personal information, because that's the whole life cycle of information. And the longer you have it, the more likely that something could go wrong with it. And even getting back to the duty to safeguard, even having the availability, maintain the integrity of the information is important.
And this is one where I know school divisions use a lot of these kind of services. Individual teachers, individual schools sometimes even do them. There's often standard form contracts that you have. All those standard form contracts must comply with these provisions. If they don't cover that, you have an obligation to add in terms or not enter into the contract. So beware of those standard form contracts and make sure that they comply with this provision.
Agreed. What else is important, because you are dictating, in the case of those parties that are providing services on your behalf, you're dictating in terms of what the purpose is, why you're giving them the information in the first place. And so an obligation on the IMSP is that they cannot then take the information and use it for their own purposes. And you'll find this a lot, especially in the world of IT. You could contract with some agency, but they're providing services for multiple agencies. And it's their obligation to segregate the data of others, not commingle it with yours, and then safeguard your data. And if you ever get to the point where you want to terminate that agreement for whatever purpose, there has to be a clause in there that holds them accountable in terms of returning the data to you or destroying it to your satisfaction. So often additional terms that we see built into these agreements is the right of the primary, for instance, the board, to be able to audit or inspect the premises or the systems to make sure they're actually complying with the rules and they're not using the information for their own purposes or marketing or what have you.
And I find it interesting too that the IMSP is bound by LA FOIP, so they have to comply with the terms and conditions of the agreement. Otherwise, they're in violation of LA FOIP, which I think it could be an interesting situation when you have out of province or out of country IMSPs. So.
Well, and then when we get back to the offense provisions, which we'll talk about in a little bit, they deal specifically with obligations of IMSPs.
Yeah. So just a little bit about integrated services sharing agreements. These would be the hub, and I think also would include the VITRA type protocols that are in place as well. So there's a new regulation in Section 10 that allows, and it specifically provides for disclosure of information and refers us to the regulations under FOIP and HIPAA to what's required in those kind of agreements. And it talks quite broadly again here, assessing, planning. So it's I think it's a good thing. It's a recommended thing in any event, but this just gives us some guidance and again, something to point to say we need to enter into these agreements.
Before we move to that one, I thought it was interesting. So this is just about hub or HIPAA regulations. It does not engage other school divisions, it doesn't make reference to LA FOIP.
I think there's a provision already to enter into agreements with other local authorities to share information.
Yes.
So I think this takes it beyond the bounds of LA FOIP.
Yeah, and I think in particular, this is where there's multiple different levels of agencies that are involved. And when it points back to the FOIP legislation, it gets into a lot more granular detail in terms of who's in and who's out and what those requirements are.
There's about 2 pages worth of requirements as to what goes into those agreements. So again, if you do contemplate this, certainly give us a call and we can certainly help. I know there's a few of them out there. I know the government had drafted a sample agreement, and I know some boards have entered into those in terms of the hubs as well. So some stuff we like in it, some stuff we don't. But if you're involved in that, give us a shout and we can work on that.
And for example, if we look at 17.1 and it says the FOIP regulations, when it introduced what these programs are, it says that it's delivered by a government institution and one or more of the following. So you first and foremost, to have a common or integrated program, it starts with a government institution. So it looks like if we don't have a government institution, it may not actually qualify under the provision. But then it lists the one or more, could be another government institution, a local authority, and the list goes on and on. So it definitely would take some further analysis.
Yeah, and most of these are those, Minister of Justice, Social Services kind of agreements. So this just allows that kind of sharing in ways that make sense. Along with this, in the regulations, that new regulation 10.10, when it provides for a situation where written consent isn't required, and this is in a very, very specific, we'll talk a bit more about consent. This is a very unique circumstance, and it requires that the information actually be recorded, that how the consent was obtained and how that is shared. I think that, again, this is one of those things that may be helpful to the sharing of the information so that the individual involved doesn't have to get written consents from 5 different organizations in order for the information to be shared. So
reviews, this is what happens when something goes awry with the access to information process or other. So I'll just go through a little bit of background on review, and then we'll talk about some of the new grounds for review. If access is denied, often we're going to get that request for review from an applicant or a third party, and then we get into a very formalized process. And we go back and forth, there's submissions, we already talked about index of records, and at the end of it is a formal report that gets published to our website if we can't resolve it informally. But usually it was because access to the records were denied in full or part. There are some additional grounds that I want to introduce to you now. So on this particular slide, some of them are that if an individual is not satisfied that the fee was reasonable, that was estimated, or they believe that the fee should have been waived, or that the application that they made to the board was transferred to another body, and they're not satisfied that the other body had a greater interest. And so they ask our office to take a look to see if we agree. We did do and have done reviews on these particular grounds before, because there was kind of an implied understanding that these were grounds that we could go forward on, but now it's explicit. So it's even that much clearer that our office has the ability to review those issues. This is new. This language is found in the review section, but it's really about breach of privacy. If the individual believes that there's been some inappropriate collection, use, or disclosure of their personal information that's not in compliance with the Act or regs, then they can request a review of our office. In the past, we just dealt with these under our privacy powers, but now the language might change a little bit, and we may have actually say we have a review and an investigation underway simply because of this. But it's not so odd because we already had the same in HIPAA. So a little bit different. Now, the next section is reasons in which the commissioner can dismiss or discontinue review. So it's different from the disregarding, which happens when that first 30 days is still running, the clock is ticking away, 30 days has not yet expired. When we get the request for review after the 30 days or after an extension of 60 days, which sometimes can legitimately be requested by a public body, then we get a review. So the applicant has requested the review of our office, and the commissioner has to make a decision as to whether or not we're going to go forward. And he can dismiss it at that point, or we open the file, we start the review, and then we discontinue the review. Usually it was because we found it was frivolous or vexatious, not made in good faith, or involved a trivial manner. We have some new grounds. One is that the matter in which they've complained to our office, it doesn't affect the applicant or the individual personally. Even though when it comes to a breach of privacy, the commissioner might still do an own motion or an office initiated investigation because there's enough there for him to be concerned. The next one is that the individual has failed to respond to requests of the commissioner. So just as in the case where there might have been an abandoned request, like you've gone back to the applicant and asked them for more information and they're not responding to you, we as well can discontinue a review because the applicant's not cooperating with our office. We may also dismiss or discontinue a review if it concerns a local authority or professional body that has an internal review process that's not been used. We see this more in the health sector when it comes to like a physician, let's say, and there was a complaint that was made to the College of Physicians and Surgeons. So rather than open a separate file, we say, no, we defer to the college in this case, and we will let them conclude their investigation on their own. Or if there's another act or some sort of a review mechanism that does involve personal information that hasn't been utilized, we too may say, no, we're not going forward in this particular case. In addition to that, and this happens all the time, it's less of an issue in a review because it's very basic building blocks that we need in order to go forward with the review. But on the breach of privacy side, we're not going to open a file if there's insufficient evidence. That was the case even before. If a person comes forward with allegations, but there's nothing to support it, there's nothing to substantiate it, why would we put the organization through all of that extra work when we don't even have enough, to feel confident that there might have been a privacy breach? And if we've already issued a report on it and it is a circumstance that is substantially similar to what we've dealt with in terms of issues in the previous report, it doesn't have to be the same person, but if the issues are substantially the same, the commissioner might exercise discretion and not go forward.
So next we're turning our attention to the issue of appeals. And this is where an appeal can occur under certain circumstances where there's been a recommendation by the commissioner and the board has to decide whether or not to follow that recommendation or not. And with it, the new provisions are that, or actually they're just amended, that, and I'm referring to section 46, that where there has been a decision by the commissioner and the board decides not to follow the recommendation, an individual or applicant or third party may appeal that decision to the court. Now, the new addition in this section is actually the individual, because it makes reference to individual for the first time, and no one knows who that individual may be. But so that's the addition to that subsection. And it also permits the individual to appear as a party to the appeal in court, in addition to the applicant or the third party, as well as the board. The next slide deals with section 47, subsection 7 and 8. The new provisions in this area are added provisions. And in this case, the court also gets to decide whether the board's decision was authorized or not. And if it was finding that it was not authorized, the court has the ability now to make new orders of ordering the board to reconsider the decision and proceed in accordance with the LA FOIP. subject to whatever conditions the court considers appropriate, or make any other order that the court considers appropriate. And these are new sections that are added to LA FOIP.
And I think it's really significant because what we're seeing now is the potential for a review of the commissioner's decision. It's de novo at the Court of Queen's Bench of a privacy breach, because it's now the individual who could be the individual who came forward with a complaint about collection, use, and disclosure of their personal information, which now gets appealed. Previously, only reviews that involved access denied or related issues would go to the Court of Queen's Bench if they were appealed by the applicant or third party. Now we have a new player. We have the complainant or the affected individual that can go forward.
Subsections 747, subsection 7 and 8 is also new. And this is where the court finds that the board have an authority to make the decision that was subject to the appeal, that the court shall not order the board to reconsider the decision. So in other words, if you have authority to do it, the court is not permitted to order the board to reconsider the decision. So this is a new subsection.
Yes. All right. I know we're getting short on time, so I'll try to speed it up a little bit. The next section is on consent. And before I get into the amendment, again, just a little bit of background. I think individuals often don't recognize that laws like LA FOIP recognize the fact that in order to do the good business that you do, you need to be able to share, collect personal information without consent. So if it relates back to your programs, your services, your mandate, you generally don't need consent at all in order to use that information. But again, respecting the need to know principle and the data minimization principles. So on top of that is the old provision used to say that if you did need consent, that it needed to be in writing unless it was not reasonably practicable in order to get that written consent. Now we have language that looks a lot closer to that which is found in HIPAA. So a number of different obligations here. And the first is that, and you'll see a lot of musts. These are a lot of shalls, it has to be done. So in the event that consent is required, and often consent is required if it's what we call a secondary purpose. It's not quite related to, what you do on a regular basis. It's something outside of that. And usually it's disclosures to third parties if you can't find a circumstance that you can disclose without consent. So if you do need that consent, it has to relate to the purpose for which it was required, must be informed or knowledgeable. It has to be given voluntarily, which means you cannot coerce or do it through misrepresentation or fraud. So it has to be on the up and up.
And the onus would be on the board to prove this.
Yes, it is. In addition, a consent that is given by an individual can be for a limited period of time, or it can be extended. However, you don't want to leave it so open-ended that the individual would be shocked that, I gave you consent, but I wasn't expecting that consent to be valid for the next 30 years. After I moved on and I graduated from school, it should no longer apply. So there should be a mechanism in place in order to revisit those consents and refresh it when needed. Now, express versus implied, what does that mean? There's actually 3 forms of consent that we deal with on a regular basis in HIPAA. The third is deemed consent, but it doesn't come into play in LA FOIP. Either you need express, implied consent, or no consent at all. Express is the gold standard. It's the opt-in. The person says, yes, I know and understand what I'm consenting to. You have my consent. And to make it really strong and clear, I'm even signing on the dotted line. Implied consent is, it's still knowledgeable. You've still explained to me what's going to happen or what won't happen if I don't consent to the use or disclosure. And it also should be very specific in terms of what you're using my information for and who you're giving it to and for what purpose. But implied, I don't actually go as far as signing on the dotted line. It is instead of the opt-out you think of. And often people will have checkboxes. And so you check in, that is your opt-in. And if I opt out, I'm choosing not to go forward. Express consent need not be in writing. So I'm not signing on the dotted line, but maybe I'm in a small town, not close to the board. Someone calls me up, they've confirmed my identity, they're sure it's me, and I'm not there to sign on the dotted line, but you can document what I've consented to. And so that way, if there is a disagreement down the road, at least you have the documentation to say, no, 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 it was my understanding at that time that you consented to this particular data transaction. And this is that provision alluding to earlier, which is that you can, in some circumstances, rely on that consent that was gathered by another local authority. But of course, that's if you believe the consent does meet the requirements of LA FOIP. And so it's really putting that to the test. But in a lot of cases, you know, it's pretty straightforward. It's a written consent, it's expressed, it's signed, it's dated, it has the details, and then you can feel comfortable going forward. I know it wasn't captured on the previous slides too, but a consent, a true express or implied consent, is revocable.
I think in terms of consent, this is a practical application of consent here, but even if you're doing these over the phone, you need to document this stuff. You have the onus of showing that there was consent, and you have to show that how it was obtained, when it was obtained, for how long, and the details. So the onus is on you as a board to document whatever way it is that you're getting the consent.
Agreed.
Next, turning our attention to offenses. Just so that I don't cause massive panic, I wanted to confirm that offenses still remain subject to the consent of the Attorney General, so that's not been a change. So don't expect that there's going to be a rash of charges under the Act. This is still subject to the consent of the Attorney General. The subsection 56 has been amended and has been extended in many ways. So this slide shows that the fine is no more than $50,000. This is an increase from the original legislation. Originally, it was $1,000. So it's jumped substantially between the previous amendment to now. So there's a fine of no more than $50,000 or to imprisonment for no more than 1 year, or to both. Could be potential outcomes. The next slide talks about, there's again an increase from $1,000 to $50,000. And in this slide, the focus is on adding a new offense, which is the willful destroying of records. And it would be by any person. So that does not require a person to be connected with the board or school division. It could be any person. And it's an offense to just willfully destroy any record governed by LA FOIP where it interferes with the functions of the commissioner. The next slide focuses on employee. This is a new provision in the Act. So no employee of the board and also no employee of an IMSP is permitted to knowingly disclose or direct another person to disclose personal information, which would constitute an offense by the board or an IMSP. Further, no employee of the board or an IMSP shall willfully access or use or direct another person to access or use personal information that is not reasonably required by that individual to carry out a purpose. So these are new offenses under the Act. And just for clarity, where there is an offense committed, there could be a fine, imprisonment, or a combination of the two as a consequence. So there are some significant provisions in this provision. The last slide deals with a board employee. So every board employee who contravenes these provisions is guilty of an offense. And again, this is a brand new provision. You're liable on summary conviction to a fine of no more than $50,000, to imprisonment for no more than 1 year, or to both, regardless of whether the board has been prosecuted or convicted. So this means that there doesn't need to be charges laid against the board or the school division. An employee can be charged with regardless of whether the board is charged or not. And that is a substantial change in the legislation.
So when we go back to the beginning of our conversation about the policies and education of board employees, this is one that you might want to make sure your employees are aware of, because it's relating to their personal liability here. Fairly substantial liability, actually.
Yes, it is.
And one of the things that our office looks at when we're trying to determine, well, who is responsible here? Is it the local authority, or is it the employee that just went rogue? We look to see, well, did the local authority, did the board do its due diligence? Did they have policies and procedures? Did they do training? Did they have proper supervision? Were they running audits? And we go down that list, and then we get to the point where we ask the question, should they have known better? And if the answer is yes, then that liability shifts.
Excellent point. So just a couple miscellaneous provisions here that we thought you should know about. The authority of the head is designated under the LA FOIP as being the chairperson of the board. And previously, it did allow for delegation to the officers of the local authority of the board. It now has added the word employees, just to clarify. In many cases, probably many of you listening are actually performing the duties, the delegated duties of the head. This is the change. The delegation has to occur by the board, so it should be done either through resolution directly, or it can be done through the application of policy. Police services are now specifically subject to LA FOIP. They weren't before. So this is a police service or regional police service. So they are now, you can make application requests to them as well. There are new forms, and these are great. They've actually got a little bit more detail in them. They're a lot clearer for the applicant. They add things like asking them to attach their authority if they're acting for somebody else. And they also ask them to set out a time period. So I see these new forms as being very helpful to us as boards. And if you've been handing these out or referring people to them, I mean, they're obviously on the website of the Office of the Privacy Commissioner, but just make sure you're using the new forms because they're better.
Just for clarity, when they're acting as authorization for somebody else, in family law situations, that could be a court order or an agreement, provisions identifying who has access to information, could be a guardianship agreement. You could be looking at things such as power of attorneys, potentially. So it's helpful to have that actually added into the form so that people understand they have to demonstrate that they have that authority to request this information.
And if you want to see the forms, they're right at the end of the regulations.
So what can you do other than feel overwhelmed? I'm hoping that's not the case, but there is a number of amendments, and we understand that there's going to be a little bit of a learning curve. We'll take you through those next steps right now. So first off, get familiar, get comfortable with the act and the regulation. I know it's a little bit different, even for myself, flipping through the act that hadn't changed in 14 years, and then all of a sudden I have new sections and things appear on different pages, and even understanding how one section now plays off another new section and how they work together. Because in some cases there's information in the act, but then like with the IMSPs and some of those elements, there's additional considerations within the regulations. So really looking at the acts and the regulations as a whole, but also checking out some of the resources talked about, which are some of the ones listed here: the IPC Guide to Exemptions, Duty to Assist, the blog, and some of the other guidelines and the draft rules and procedures as well, not listed on this slide. But our office also has best practices for information sharing agreements that we can include in the email that goes out with the slide deck. I think it's a really great resource. We developed it a number of years ago, but because the elements that LA FOIP is introducing have been around forever because they're based on privacy principles, I think it'll still be a helpful starting point for you when you're working on either revising or entering into new agreements with these IMSPs.
I believe that you actually have new resources as well for fees and quick fee calculations.
Yes, what we did was we had the analysts go through all of our old resources, and if there was anything that needed updating to address the new amendments, they've done so. And I think in total we updated over 20 resources.
Excellent. And those, I mean, highly recommended to noodle about the website and find a lot of good stuff.
And so what do? These are the steps. Review your practices, take a look at your collection, use, and disclosure practices, make sure that you're adhering to need to know, data minimization, but also looking at, do we need consent? And if we do, how are we going to update if we have particular forms that we need signed? Are we covering all those elements? Are we making sure that it's an informed consent, for instance? But also looking at all the contracts and agreements, as I just mentioned, and you're thinking about all the different stakeholders and relationships that you have and what really needs to be formalized. Working with the SSBA on developing those policies and procedures, and even some more specific ones on how do you respond if there is a privacy breach. That's a big one. And how do you determine at that time that there is potentially a real risk of significant harm? Because if you do have to notify, you should be doing it in a timely fashion. I know individuals get really upset if they feel there's been undue delay in terms of that notification coming to them, because they do need to protect themselves. A perfect example, I know we're really short on time, of where I believe there was a real risk of significant harm was a home care worker. She was out on the road. She, of course, had to go to a number of different stops in her course of her day. She had all the patient files with her in the trunk of her car. And on the way home, she stopped at the grocery store. She didn't lock her car. Someone went in, popped the trunk, got access to those files. What was contained within the files was how to gain access to these people's homes, because in a lot of cases they were disabled and handicapped. So Irene's key to her back door is under the flower pot on her back step. There is real risk of significant harm to an individual in that case. So they took immediate action. They contacted them all by phone, and they made sure the steps were taken to protect those individuals. So, you know, it's important to have a plan in place, because this could happen on the turn of a dime, and you have to respond. You have to respond now. And then, of course, training sessions to make sure your employees are up to speed. And our office recommends that that is done on an annual basis.
There's the privacy and access website that we work on, the saschoolsprivacy.com. That's where a number of resources are related, that are directly related to education, some links. We're, as I'm sure many of you are, we're working off the side of our desk on these things. So we're constantly trying to update. We'll make a major push on that this spring. Any of you that have what you think are good policies, practices, we'd love to hear from you so that we can share those out, and we will do our best to try and share those with you as well. And as you all know, and if you don't, you should by now, certainly welcome and able to talk to you, help you with any specific issues.
As are we.
Yeah. So there's another question that's come in. Are there any new guidelines that school divisions need to be aware of regarding police investigations in school? No. That the provisions under LA FOIP with regard to sharing information with police have not changed. That section is still there. It's a discretionary section. The board has to consider, first of all, there has to be a request from the police for purposes of an investigation. Then you have the discretion. You need to look at all the circumstances. Is this the right opportunity, time? Is the public, think about the public good, think about the relationship with students, relationship with police. There's a number of factors. And as I said earlier, when you're considering whether or not to allow the police to speak to students, to do things, follow the processes that you need to follow, but also document. If the police want to do that, ask them to put in writing that they request that they get this information. Then when you give them the information, you say to them, we're providing you this information under our ability to do so under section blah, blah. I can't remember the exact number of LA FOIP. So you've got a real clear idea. So if the parent or student comes back to you and says, hey, what the heck, you have the documentation again. You're always going to have to prove that you've done the right thing. So no, things haven't really changed there. The fact that they're now included under LA FOIP means that they are now subject to getting information requests. So we could go to, anybody could go to them just as they would to the school division.
Exactly. So if you have any other questions, of course, you know how to contact. And in terms of our office, we have the general website listed there. We provide summary advice, it's confidential, try to make sure that we point you in the right direction. And if it's something we think is best, discussed with the SSBA, then, we'll definitely let you know that. But there's nothing wrong with seeing what kind of advice you can get on these very complex issues.
So we thank you all for participating today. If there's any other questions that come up, any of the three of us would be happy to answer those. So thank you very much. Any feedback on this particular webinar would also be appreciated. We don't have a formal review process, but boy, your emails back on suggestions, perhaps other topics that would be of help to you, that's great. We have recorded this. It will be taken and edited, and we will also let you know where and when that can be accessed in future if you want to share it with other people. Thank you, and I think that's it. Goodbye.
Bye.
Bye.